and welcome to everyone. This is going to be the second part of our year in review series that we started last week. And we hope to provide you with some updates, things that happened in some relevant industries that will be helpful to you going forward into 2023. Before we get started, I will do my typical COVID update. So if we look at the data, again, looks good. We had a little bit of a spike there in December, but it seems numbers are normalizing. And again, it's nothing like the 80,000 cases per day we were seeing last January into February. Test positivity is at 13% of those reporting. Again, this data is of course reliant on people reporting their positive tests. Hospitalizations are down by approximately 13% over the past 14 days. Similarly, we're seeing ICU numbers go down a little bit as well. Next slide, please. We're seeing a lot of yellow on the map. That's what we like to see. We don't want to see orange, dark orange, or red. The darker part of the state is down near New York City and the surrounding areas, but again, the numbers are not too bad. Again, if we look at the new case numbers, daily case averages in the right-hand side graph, we see that New York City is completely flat over the past 2 weeks, and a number of other counties are seeing significant drops in cases, which is good news. So that is where we are as it relates to COVID, and now we can get into the substantive presentations for the day. On with us today to discuss wage and hour developments in 2022 is Subha Viswanathan. Subha has been on the webinar before to speak on these issues. Subha is what I consider to be the preeminent wage and hour mind here at Schoeneck King, so we love having him on to talk about these things. Subha, welcome and take it away. You're muted, Subha.
You would think I would know how to do this by now, Adam. All right, move on to the next slide, Kathy, please. Thanks. So there have been a few New York developments in 2022. The increase to the minimum wage and the exempt salary levels did officially increase. They were put in the state register on December 28th and went into effect on December 31st. And along with that, those increases in the minimum wage came similar increases in the tip credits that employers in the hospitality industry can use, as well as increases in the meal and lodging allowances. Just before Christmas, the pay transparency law was passed, which will go into effect in September. The COVID-19 paid vaccination leave was extended through December 31st, 2023. And one federal development that I will discuss is the proposed independent contractor rule that kind of went back to the old standards of how to determine whether someone is an independent contractor or employee under the Fair Labor Standards Act. Next slide, please, Kathy. So let's start with the minimum wage increase. In upstate New York, the minimum wage went up by $1 from $13.20 to $14.20 per hour. I'm just going to use upstate New York as kind of the generic geographical description for all areas outside of New York City, Nassau, Suffolk, and Westchester counties. There was no increase in New York City or those downstate counties. So that minimum wage will remain at $15 per hour, and fast food employees minimum wage is still $15 per hour across the state. Next slide, please, Kathy. The salary level to qualify for the executive and administrative exemptions in New York went up from $990 per week to $1,064.25 per week for employers in upstate New York. Remember that those minimum salary levels are inclusive of board, lodging, or other allowances and facilities. So if you include meals or housing or use of a company car or any other types of allowances and facilities, You can count those towards that $1,064.25 per week in New York. The US Department of Labor did announce, actually a couple of times in 2022, its intent to increase the federal minimum salary level, which is currently $684 per week for the executive, administrative, and professional employees. At this point, we're expecting it to happen in 2023. It's probably not going to be the $1,064.25 that the state currently has for the executive and administrative exemptions. So for purposes of those two exemptions, we're not anticipating that there's going to be any change to what the federal regulations are going to mandate. But professional employees in New York likely will be impacted by the increase in the federal level, because at this point, there is no minimum salary or separate minimum salary under state law to qualify for the professional exemption. But employers in New York have to meet the $684 per week to qualify professional employees in New York.
Suba, before you move on, can you just briefly discuss the significance or the consequence of being classified as exempt versus non-exempt?
Yes. So just because the exempt salary level for the executive and administrative exemptions are going up, that doesn't necessarily mean that employers have to raise the salary to $1,064.25. What it means is that if an employee meets the duties test but doesn't qualify for the new salary level test, they're going to be non-exempt employees, which means that they need to track their time, they need to report their hours worked on a weekly basis. And if they work more than 40 hours in a particular work week, they have to be paid at time and a half their regular rate for any hours worked in excess of 40. So that's always an option. You know, if you have employees that you don't really think work overtime and you're not afraid of them reporting their time and incurring a lot of costs, you know, that you can keep employees at $9.90 per week, have them report their time, and you know, that may be that's perfectly acceptable as long as you pay the overtime. Next slide, please, Kathy. The hospitality industry maximum tip credits did go up effective December 31st also. So in upstate New York, for food service workers, the new tip credit is $4.75 per hour, which means that the tipped minimum wage for food service workers is $9.45 per hour. And for service employees, which is basically anybody who doesn't qualify as a food service worker that customarily and regularly receives tips, the minimum tip credit or the maximum tip credit is $2.35 per hour, and the tipped minimum wage is $11.85 per hour. Next slide, please, Kathy. The meal and lodging allowances in upstate New York also went up effective December 31st. You can count $4.90 per meal toward the minimum wage. You can count $6 per day for lodging in upstate New York if utilities are not included. If you provide a house or apartment that includes utilities, you can count $11.35 per day toward the minimum wage. Next slide, please, Kathy. New York passed a pay transparency law that was signed by Governor Hochul on December 21st, 2022. It will become effective on September 17th, 2023. Even though the statute that was passed, the bill that was passed, has not yet gone into effect, there have been amendments that have been proposed already. We are anticipating that those amendments will likely be adopted. It doesn't significantly change the obligations under the statute. The law, as currently written, will require disclosure of the following information in advertisements for jobs, promotions, or transfer opportunities. So it has to include the compensation or range of compensation, which is basically just the anticipated minimum and maximum compensation. If it's a weekly salary, you can just do a minimum and maximum weekly salary. If it's an hourly paid position, minimum and maximum hourly rate. The advertisement also has to include a job description, if a job description exists. If a position is paid exclusively on a commission basis, employers can comply with the new law by just simply stating that compensation will be based on commission. Next slide, please. This applies to employers with 4 or more employees in New York State. As amended, the disclosure requirements would apply to jobs that will be physically performed, at least in part, in New York, and jobs that will be physically performed outside of New York if the person in the position reports to a supervisor, office, or other work site in New York. The amendment included a definition of advertise, which was not in the initial bill that was passed. So advertise will mean to make available to a pool of potential applicants for internal or public viewing, including electronically, a written description of an employment opportunity. So if you have any sort of internal posting to an intranet site, or you put a physical posting up in your workplace for a promotion opportunity, that is going to constitute an advertisement under the statute, and has to comply with the obligation to put down the range of compensation as well as the job description. The statute does require the Commissioner of Labor to issue regulations to effectuate the law. We're anticipating that they will be promulgated before the effective date, and we will definitely keep you posted once they are. Next slide. The paid COVID-19 vaccination leave law, as you might recall, went into effect in March 12th, 2021. It initially was set to expire on December 31st, 2022. On June 28th, 2022, the law was extended to December 31st, 2023. So as of right now, employees still, if they're getting a COVID-19 initial vaccine series or a COVID-19 booster shot, they're entitled to up to 4 hours of paid leave for each COVID-19 vaccine injection. And at this point, that's going to be effective through December 31st, 2023.
Suba, I'm going to jump in for a second.
Yes.
Because I know this question is going to be asked. So this extension applies to the statute that allows for pay for vaccination leave. It is not COVID paid leave, which we've referred to on this webinar quite a bit. COVID paid leave has no expiration date. So I just want to make sure that we clarify the distinction there. Thank you.
Right. Next slide, please, Kathy. So the one major federal development was that the U.S. Department of Labor proposed a new independent contractor rule, which really kind of returned to the economic realities standard that existed before 2021, when the Department of Labor issued an independent contractor rule at that point. That's went into effect in 2021. So let me talk about the new rule, which is really a return to the old rule. It kind of analyzes 6 factors to determine whether somebody qualifies as an independent contractor for purposes of coverage under the Fair Labor Standards Act. The first is the degree of control exercised by the employer over the worker. Obviously, the more degree of control, such as setting hours worked, setting location of the work, more degree of control, more likely it is that the person will be found to be an employee. The worker's skill or initiative needed in performing the work. Again, the greater the skill or initiative, more likely it is that they're an independent contractor. Less skill or less initiative, more likely it is that they're an employee. The permanency of the relationship between the parties. If it looks like the person has been working for that particular employer for a long time, with no end in sight, there's no end date to the relationship, and the employee is essentially completely dependent upon the employer for income, those are factors that are going to be considered to weigh in favor of employment status. The worker's opportunity for profit or loss is the 4th factor. the worker's investment in equipment or other resources as compared to the employer's investment, and the extent to which the work is an integral part of the employer's business. And all of these factors under this standard are given equal weight. Next slide, please, Kathy. So the current US DOL rule, which kind of changed, really 70 to 80 years of law that had developed in the courts, that rule gave more weight to the degree of control and opportunity for profit, and really limited the consideration of whether the work is an integral part of the employer's business. So essentially, it made it easier to classify workers as independent contractors for purposes of excluding them from coverage under the Fair Labor Standards Act. If this current rule is adopted, and we're anticipating it likely will be, the comment period for the proposed rule ended at the end of November. I'm sure the US DOL is going through the comments, but we're expecting the rule to be promulgated essentially very similar to what the proposed rule is. It'll make it more difficult to classify workers as independent contractors. So, the takeaway from that is you should review your current independent contractor arrangements and determine whether anybody should be reclassified. Get legal advice if you need to. And remember that having a written contract with an independent contractor, that even if the contract says, I agree that I'm an independent contractor and I'm not an employee, that's going to have limited weight when you get before the US DOL, because they're really going to look at the reality of the relationship and whether the reality of that economic relationship looks more like an employment relationship or an independent contractor relationship. Thanks, Adam. That's all I have.
Thank you, Suba. And if we've gotten a lot of good questions, both about the pay transparency law and other wage and hour issues. If you have specific questions, feel free to reach out to Suba. I will say that we published a pretty detailed blog on the pay transparency law that is in effect for all of New York State now. So if you wanted to check that, please go ahead. All right, next up, we have Nick Jacobson. Nick has been on several times to talk about New York's gun control legislation, and we brought him back because there's been so much movement and so many articles about court opinions and what's going on. So we thought it would be helpful for Nick to summarize where we are and what you can expect. So Nick, thank you.
Great, thank you, Adam. Next slide, please, Kathy. So, as many of you might recall, this really started last summer when the Supreme Court issued a decision in the Bruin case. And what it found was that New York State's proper cause requirement in its pistol permit process was a violation of the Second Amendment. Now, what the proper cause requirement imposed was it required individuals to demonstrate that they had a special need for protection that was different from that of members of the general public. To satisfy the proper cause standard, an applicant would have to show that they were subject to specific threats or attacks. It wasn't enough to say, I live in a bad neighborhood or there's been break-ins near my job. It had to be specific to the individual applicant for them to be able to obtain a conceal and carry permit. Next slide, please. So after Bruin invalidated New York's proper cause requirement, it passed the Concealed Carry Improvement Act very shortly thereafter on July 1st. And the CCIA, as written, prohibits individuals from carrying firearms in certain sensitive locations, such as government buildings, healthcare facilities, religious institutions, schools, colleges, and even on public transportation. Most important for other employers and businesses, the law also prohibits possession of a firearm in a restricted area. And the law defines a restricted area as any private property where the owner has not posted clear and conspicuous signage indicating that the possession of firearms is allowed or where they otherwise have not given explicit permission for a firearm to be possessed on the premises. Next slide, please. Okay, now as we expected when the law was passed, it was subject to immediate legal challenge. I think there's now 10 separate legal challenges pending against the law, but the front runner in that is Antoniuk v. Hochul. That's the case we've been talking to you about all along. In that case, the district court initially granted a temporary restraining order, substantially limiting enforcement. Then the state went to the Second Circuit and got a temporary stay of the temporary restraining order so that it wasn't in effect. The district court then issued a preliminary injunction, again substantially limiting enforcement of the CCIA, and it also denied the state's request for a stay pending appeal. The Second Circuit, however, granted that stay pending further review. So at the last time we came to you, that was where we stood, that the Second Circuit had granted a stay and that the law was, at least for now, in effect pending further appellate review. Next slide, please. So recently, the challengers to the CCIA made an emergency request to the Supreme Court to vacate Second Circuit's temporary stay. The state then opposed, to try to keep the Second Circuit stay in effect and to keep the law enforceable pending review by the Second Circuit. Just last week, the Supreme Court issued a unanimous decision denying the challengers' emergency request to vacate the stay. Now, that's not a final decision on the law, and two of the more conservative justices, Justice Alito and Thomas, actually issued a statement noting that the decision was a procedural step rather than a ruling on the CCIA's constitutionality. Next slide, please. So where do we stand and where are we going? As of now, the law is currently in effect because the Second Circuit's temporary stay was not removed by the Supreme Court. Where that leaves us now is that we are continuing to monitor future developments. The cases with the Second Circuit now, we're awaiting a decision from the Second Circuit as to the constitutionality of the law. There's also proceedings in district court playing out. There's other challenges playing out that may have an effect on the enforceability of the law. And ultimately, we expect to end up before the Supreme Court at some point, given the nature of the law and the significant challenges to it. Also, given the rather conservative leaning of the current court and New York's goals in promoting gun control as much as possible, it is likely that the Supreme Court does take issue with at least some portions of the law. For the meantime, what employers and business owners can do is they should consider adopting their own policies and posting appropriate signage, advising of their rules regarding possession of firearms on their property. This could take a while to play out. There's likely to be future changes. So employers and businesses really should take affirmative action if they desire to either allow firearms and let people know that firearms are allowed on the property, or to advise employees and visitors that they are not allowed to prohibit a firearm on the property. And Adam, that's all for me.
Nick, thank you so much. Okay, next up, we have a very special guest, Amber Lawyer. Amber is a lawyer in our cybersecurity department. Amber has been at the forefront of these cybersecurity issues for the past several years, and she is here to talk to us about developments in the cybersecurity arena in 2022. Amber, welcome on.
Thanks, Adam. Thanks for having me. I will be doing kind of a high-level overview of the cybersecurity and data privacy landscape in 2022. I think if we want to go into specific details, this would be a 15-part series on the developments in 2022, just because we had so many changes in the law throughout the year. So what I will do is just kind of talk generally about the legal review and update that we had in 2022, and then kind of the fundamental change we're seeing in the marketplace in terms of data privacy and cybersecurity, and what is important for your business to know going into 2023. I think first, I guess foremost, what's most important to note is that privacy and cybersecurity laws, rules, regulations are changing and increasing going into 2023, where we have a landscape that's becoming much more prescriptive. Privacy and cybersecurity is touching every single area of the business. And so we have a rapidly increasing and changing marketplace. It's really important to stay on top of it. I know we've had quite a few folks from the cybersecurity team talk about specific data privacy laws throughout 2022. I'll highlight some of those, and then feel free if you have any specific questions to email me after. It is important to note that we do not have any federal general consumer data privacy legislation at this time. In May 2022, federal legislation was proposed, the American Data Privacy and Protection Act, but it stalled in committee. And this is really important because we are likely to see a proposal of this legislation again with the new Congress. This is likely to be renewed, and President Biden has come out and said that he is hoping that we can pass some kind of federal data privacy legislation. The way the American Data Privacy Protection Act is written, it does not exempt nonprofit institutions, higher ed institutions, like some of our state data privacy laws do, and it will affect businesses involved in the collection of personal information of consumers. So it's really important to note, keep your eye out that we may have federal legislation in the data privacy cybersecurity market in 2023. We currently have 5 state consumer data privacy laws. So effective prior to 2022, we had a California privacy law, which was actually amended by a proposition ballot. And now, effective January 1 of this year, we have the California Privacy Rights Act. We also, effective January 1 this year, have a Virginia Consumer Data Protection Act. And we have a Colorado Privacy Act, a Connecticut Data Privacy Act, and a Utah Consumer Privacy Act that all will become effective throughout 2023. Colorado will be effective in July, Connecticut will also be effective in July, and Utah will be effective in December. What are these privacy laws? So we have a state-by-state analysis of consumer data privacy laws. So if you are an entity that is collecting personal information of consumers located throughout the country, you may be subject to these data privacy laws. So if you sell goods in other states, if you have consumers that are purchasing in other states, or you have employees in other states, you may need to worry about these data privacy laws. What do? They afford rights to consumers in relation to the information that you collect on them. And all of these laws kind of follow in the wake of the Facebook Cambridge Analytica scandal, in the wake of legislation coming out of the EU, which is called GDPR, which I'll talk about in a moment. These all follow that framework, which essentially says consumers have a right to the information that you're collecting about them. And as a business, you have obligations in relation to that data. What are those obligations? You have to provide adequate disclosures. You have to provide proper notices. You need to update your privacy policies. Consumers, pursuant to these laws, have a right to make specific requests in relation to the data you have. So they have a right to request access to the data or deletion to the data. These laws also prescribe certain cybersecurity standards. So if you're subject to them, you have to have certain cybersecurity measures in place, like multi-factor authentication, industry standard encryption, and things like that. And finally, they impose certain contractual obligations on entities in relation to their service providers. So what does that mean? If you're a company that has a service provider that processes your payroll, or has a service provider that processes personal information of consumers, if you have Google Analytics, if you have any other kind of third-party processor, your contracts with those entities need to be modified to ensure that they have appropriate and proper contractual language pursuant to the law. What this really means is that you have a downstream obligation to ensure that if you're providing personal information to third-party vendors, you're ensuring that they will protect it. So really important there. Because we don't have any federal legislation, unfortunately for businesses, we kind of have this state-by-state approach. And that's why on the 1st of January, you all got emails saying we have updated our privacy policies, because businesses now will have privacy policies that have a detailed section for California and for Virginia. And as Colorado, Connecticut, and Utah come into play, we will also see those provisions added to privacy policies. Important to note, we have at least 8 other states that are likely to pass legislation in the privacy area. And so we will see further changes in this field as well. I know my colleague Mario was on a few weeks ago to talk about biometric data privacy. Currently, Illinois, Texas, and Washington have biometric privacy laws. Illinois is the most active, of course, as he described. We also have localities that have biometric privacy laws, including New York City. And so if your entity is collecting biometric data, it's important that you're obtaining appropriate consent before collecting that information, and that you have the required retention, disclosure, and destruction policies in place. On an international landscape, we also saw quite a bit of development in privacy and cybersecurity legislation. So the General Data Protection Legislation, which came out of the EU in 2018, it had quite a few changes in that out of the EU, the United States was deemed an inadequate country, and that because we don't have federal legislation, transfer of information from the EU to the United States was restricted unless you had certain contractual provisions in place or adequate protections. Because the EU found that the United States didn't adequately protect consumer information, businesses had to find a way to get information from the EU to the US, especially if you're an international company and you're selling information you're selling goods into the EU and collecting information to do so. Because of that, we saw some changes in the market for GDPR. There is a proposal for a second privacy shield, which is a self-certification mechanism to allow businesses to prove up that they have adequate cybersecurity measures. And we also saw a modification to the standard contract clauses. The standard contract clauses were contract provisions that entities needed to execute. So if you've ever seen a data protection addendum or what we call a DPA, these standard contract clauses were provisions that were attached to those DPAs. They are required to be executed if you're going to transfer data outside of the EU into the US. So many of you have probably seen them on tech contracts, on vendor contracts. Those were updated in 2022 as well. And so your contracts all should have been updated. We saw a couple more developments internationally. China has its own data privacy law now and cybersecurity law. Canada and Australia are making similar changes. And so it's important to note that if your business has any kind of global outreach outside of the United States, you not only need to worry about these US state laws that I was just mentioning, you also need to worry about international compliance. And so what does this all mean? You really need to start focusing on privacy and cybersecurity. It needs to become integral in your business. If you're forward thinking and thinking about it before you're developing business, it's helpful to build privacy and security into your design, into your user experience, because to change things on the back end is more difficult. We had a couple of sector-specific updates as well. The Gramm-Leach-Bliley Act updated the safeguards rule, which will be effective next June. And so that mandates certain technology obligations on entities that are financial institutions processing financial information. We reported on this webinar before that there was a new New York State electronic monitoring law for employees. And so if your business is monitoring employees, you need to provide adequate notice. And so that was new as of May of last year. We also had some development in the relation to children's privacy out of the FTC and out of California and other states. So if you do any kind of collection of children's information online, it is important to note that you are more regulated now than ever. And so you need to keep an eye on that. And then finally, where we really saw some development was in the realm of data breaches and enforcing state data breach statutes. So in New York State, we have a data breach statute called the New York Shield Act. And pursuant to that, for really the first time since it became effective in 2020, we saw some pretty big enforcement out of the New York AG's office. So we had several big settlements come out of the New York AG's office, including Wegmans for $400,000, Carnival Cruises for a $1.25 million fine, IMED for $600,000. And so we had a lot of enforcement action coming out of the Attorney General's office. What does that mean? If your entity has a data breach, a security incident, it's very important that you review the incident, determine if it rises to the level of a data breach, meaning that you have unauthorized access to or acquisition of personal information, and that you're reporting appropriately and then taking appropriate remediation steps. So are you adding in appropriate cybersecurity measures? Do you have multi-factor authentication? What also comes with that, and if you don't remember anything else I've said today, is you really need to have cybersecurity insurance. If your business does not have cybersecurity insurance, it's time to try to get it. I understand premiums are on the rise and the cybersecurity marketplace is really kind of the wild, wild west. But cybersecurity insurance is crucial for businesses. We saw quite a bit of infrastructure go down this year in relation to hacking events. And so it's very important to have cybersecurity insurance. Just a couple of final notes, and then I'll turn it back over to you, Adam, unless you have any questions. It's very important to get your privacy policies, cookie pop-ups updated, and to do an annual review of those policies because they're more important now than ever. That's where you provide adequate disclosure and obtain adequate consent in relation to processing personal information. If you are doing any kind of marketing, cross-contextual behavioral advertising, if you're using Facebook, Instagram, if you're doing anything that would be considered in the background on websites, it's important to note that that is now regulated more than ever. And so you need to ensure that you're doing that properly and that you have proper notices in place. You need to have an incident response plan and run tabletop exercises to prevent a data breach and to know what you're doing if you do unfortunately have a cybersecurity incident. And then finally, as I mentioned, it's really important to obtain cybersecurity insurance. Adam, do you have any questions for me?
No, but that's just because I don't understand everything that you said. So I would say that if anyone has any questions about cybersecurity, you are the person to call. Amber's contact information will be on the last slide of this presentation, so please feel free to reach out.
Yeah, thank you. And if anyone has any specific questions, I'm happy to come back and go into detail about any of those laws that I mentioned.
Thank you, Amber. All right, last but certainly not least, Seth Gilbertson is on to do part 2 of his presentation on looking forward, looking back, and the higher education landscape. So Seth, welcome.
Thanks, Adam. I'll try to move quickly here. As Adam said, this is the second part of this this series for higher education. As we know, we're kind of in the middle of the year for higher education. So a lot of these are 2022 developments that will bleed into 2023 and we'll continue to watch as they develop. Next slide, please. So certainly something that didn't start in 2022, but continued to intensify, and we expect it to continue to intensify in the next year and years. Our divisions on campus over speech issues generally related to politics that are often exacerbated by social media. Next slide, please. One of the things we've seen that I'm going to point to here that I don't think we will see anytime soon in New York, but certainly in other states has been a trend, has been what are often deemed to be parents' rights bills. Florida is the sort of the most noteworthy example, although there are similar laws taking effect in Arizona, Kansas, Louisiana, Georgia, and a bunch more that have been proposed and may be going into effect in the next year. A lot of these are bills that limit things like library book access to children, or the types of lessons that can be taught in certain subjects. History is a big one where there are oftentimes limitations placed on faculty members. Of course, some of those laws butt up against what traditional aspects of academic freedom and free speech rights of the employees that are most affected. As we see, we have a lot of other issues here that are affected by speech and politics on campus too, all of which are particularly sensitive issues and things that we're focusing on in the higher ed space. Next slide, please. Anybody who watches college sports in any capacity or is even aware of them has noticed some big changes lately. A lot of this comes down to redefining what a student athlete means and sort of the business aspects of big time college sports catching up with the traditional notions of college athletics and amateur competition. A lot of this is I think it's noteworthy to be clear that a lot of this is being driven very much by the big money-making sports, primarily college football and men's basketball, and sort of the other sports which make up the largest percentage by far of student athletes and campus competitions, intercollegiate athletic competitions are getting sort of dragged along with the big time sports, and that just because the attention goes to where the money is, and that's where it is right now. So we're going to continue to watch this, but there's already been a sea change. There will continue to be more changes. It's very possible that there'll be serious litigation. There already is ongoing litigation, but that litigation will come to a head sometime over whether college athletes, particularly again big time intercollegiate athletes in college football and basketball, are employees of the institutions that they represent, that they compete on behalf of. Next slide, please. Mental health has affected particularly employers and many different sectors across the United States, and it's been particularly acute. Its effects have been particularly acute over the last couple of years as we come out of the pandemic, and certainly as we are all trying to survive the pandemic. This has hit college campuses very hard. What was already a great a trend increasing in the number of students that presented on campus with mental health issues, with seeking accommodations, and who had disabilities and things like that related to mental health. That trend has greatly increased. It's also continued to affect and impact more so on the employment side as we continue to deal with more common accommodations on the mental health side. This is particularly challenging for faculty sometimes, or for administrators who are dealing with these requests from faculty. And then the other place where we've really seen an impact is in handling of high-risk students. A lot of litigation and challenges to the policies of colleges and universities trying to deal with students who are at risk or seen to be at risk. And so we'll continue to watch that, but certainly with some big time litigation at places like Yale and Princeton and Stanford over the last year or two, there's been a lot of focus on that. So next slide, please. Litigation has continued. In fact, well, over here, some of the litigation has been filed in the Western District of New York. Right behind me here, there's a very active plaintiff up in Niagara Falls that's been suing colleges and universities all over the country for web and digital access. OCR has been active again due to some changes in their case processing manual. There are regulations on the way. I actually anticipate that those regulations around web accessibility in education may be out in 2023. They've already started talking about them openly. The Department of Education has. So we'll be looking at that. If you haven't looked at your web and digital accessibility on your campus recently, if you haven't been forced to because of litigation or because of an OCR complaint or something like that, you should be reviewing that on your own now, because you're going to be confronted with that litigation or that complaint or those regulations. It's almost a guarantee at this point, if you haven't already, that you will. So get ready for it. We all dealt with this back in 2016 and 17 as a major issue. It's becoming a major issue again. Absolutely. Next slide, please. Enrollment challenges. I don't need to say much for colleges and universities here that are experiencing that themselves, but it's continued to reshape the landscape of colleges and universities, both small private institutions that have been acutely impacted by enrollment challenges, and even big institutions that have been impacted by changes in international student enrollment, particularly in graduate programs. But these have been a defining factor of the changes on college and university campuses over the last couple of years, and that will continue. Next slide, please. And finally, Amber talked about it a lot. We're also impacted. I'm not going to say too much about it, but certainly cybersecurity challenges have impacted higher education severely over the last few years. And I just say keep your eyes out. Bonds, higher education, and cybersecurity practice groups are going to be collaborating on some webinars and other guidance activities over the next couple of months. So keep your eye out for that. Thank you.
Seth, thank you so much. Two quick housekeeping items before we leave you for the day. Number one, someone asked if the slides will be available. Yes, you can go to the BSK or Bon Schoeneck King. If you Google Bon Schoeneck King, you go to our main website under webinars and presentations. We typically have the slides up within a day or two, so that's available. The second thing, we received a question about the ruling from the Onondaga County Supreme Court on Friday that dealt with the healthcare vaccine mandate. I can tell you we reviewed it and we will be putting up a blog on its impact this afternoon. So please be on the lookout for that. If you need to contact anybody, here is our contact information. Thank you again for being with us, and we will see you next week.